Thank you so much for agreeing for this panel. I'm very excited to hear your questions, your comments, your expertise with us today. Mike, I'll go ahead and toss it over to you to some questions.
Dr. Perillo, thanks so much. I thought I was going to have to do all of those biographies, so thank you so much for doing those in such an efficient way. I want to thank the University of New Mexico, of course, for being one of the few entities in my personal or professional life to invite me back a second time, so I'm very appreciative of that. And of course, I'm appreciative as well to the weekly webinars that we get with such a great master's class every week of many different topics in forensic psychology. So again, very appreciative of all the years that University of New Mexico has done that. Also want to quickly say a shout out to a couple of professionals who helped out immensely in this presentation and making sure that this special moment with three judges really went as well as it possibly could. I want to thank Dr. Otto, Dr. Richardson, Dr. Butts, and Dr. Polyakov for their wonderful contributions to my questions here and to their friendship, but also to making me look a lot smarter than I am by their assistance here. So thank you to all of you. And to Dr. Perillo as well, thanks for your feedback. And I do want to tell the panel that Dr. Perillo will take over if there's some Zoom problem or difficulty, like there has been in prior presentations. Dr. Perillo is going to take up the questioning. He has my questioning just in case that happens. Thank you, judges, for being here. Just one more or two more words to make sure I've covered all my bases. None of us are getting paid for this. Matter of fact, all of these wonderful people are taking time out of their busy schedules to be here with us. And I'm so appreciative and feel honored that all of you have done that. So thank you so much. But none of us are getting paid. We don't have any financial investment in it. We're not selling books or magazines or anything else. And the opinions that you hear expressed today are those of the participants in this panel only, not the University of New Mexico. So they may agree or disagree. We don't know, but it's solely the opinions of those who are here today. All right. I think I said everything I'm supposed to say there. All right. So I'm going to go through the panel here and ask questions, and I'll start with and rotate across the panel here to each of you. And hopefully we can get some things that are very important. Now, in generating this topic, I've often thought, how are judges responding to my testimony and how are they responding to my reports? And I'm sure that many of us have had that same kind of thought, but how is this really going over and why did the ruling come out the way that it did? So today, I thought this would be a great opportunity to try to get some of those answers. I'm going to start off with Judge Speiser. Judge Speiser, first question. Do you think that the court and criminal justice systems are equipped to handle the increasing percentage of criminal defendants with mental health and substance abuse problems? And if not, are there changes you think that could be made to better equip the courts and criminal justice system to handle those challenging cases? Can't hear you, Judge Speiser. Your audio's off.
Unmute.
There you go. You're on.
Okay. Thank you for the opportunity to address this very illustrious audience. And to answer your question, we have come a long way since 15 years ago, when basically we were drowning with a tremendous number of people coming into the court system that had mental health issues and substance abuse issues, or a combination of both. And so what my perspective is that what we started to do here in Fort Lauderdale and Broward County is we created a task force that basically brought together community participants and providers of mental health services and substance abuse issues. And we also were able to create additional funding through county commission subsidization of our operation here. And so what we did was we formed a felony mental health court. I believe it was the first one in the nation. And we were able to basically handle everybody in the criminal justice system that had purported mental health issues and try and link them up with treatment and services that would enable them to regain competency and proceed with respect to their criminal charges. So to answer your question in a more succinct manner, we have come a long way from about 10, 15, 20 years ago, but there still is a long way to go.
Okay, thank you, Judge. Judge Singhal or Judge Scherer, any additional comments on that question? Oh, I think you're both off mic.
There
So
we go.
just
Okay.
there you go. Judge Singhal, you got off the mute first.
Yeah, no, I too want to just thank you all for including me in this presentation, and I really am grateful to Judge Speiser for his commitment to mental health for all these years. He just spoke about 15 years ago. I think really it's more like 30 years ago. He's been really spearheading efforts to deal with mental health issues in the courts for decades now. And then we go from mental health to substance abuse to now this concept of codependent issues. And so a lot of them are interrelated. From my perspective, I think a lot of it has to be handled at the state court level and not the federal level, because that's where the resources really need to be committed to mental health. Different states have different problems and at different levels as well. But other than that, I agree completely with what Judge Speiser said.
Judge Scherer, any comments on that? All right, so Judge Scherer, we're having trouble getting you unmuted there. So I'm going to move on to the next question, and then Judge Scherer will come back to you, okay? Judge Singhal, this next question is coming to you, and I've had the good fortune and honor of appearing in front of all of you in court proceedings. So this next question, though, certainly applies to everybody in this audience here today who wonders about this. What are some of the things that you all as judges look for when evaluating the credibility and usefulness of expert witness testimony? What are the key features that you seem to look at? And Judge Singhal, I'm starting with you on that.
Sure. So, the court always is interested in a witness that will help get to the right answer. And in many of these issues that we deal with, we're not talking about testimony that's in front of a jury. So findings of competence, for example, many judges will take the time to get behind the evaluations, to know about the tests, to know what the different methods are. And so I think that for credibility purposes, the witness really should assume that the judge is going to get behind the report and not just take the testimony and the report at its face value. Those witnesses that can come in, that can support what they're saying and can answer questions from the judge, I think are always the most credible ones for me, at least.
Thanks so much. Judge Scherer or Judge Speiser, anything additional on credibility and usefulness of expert witnesses?
Go ahead, Elizabeth. I'll follow you.
Thank you, Judge. I think that one important thing is that there's always going to be information that may be brought out by either side that the expert wasn't aware of. And to me, when an expert finds out new information, sometimes it's very important information. The expert who's willing to consider that and instead of sort of digging their heels in and saying, no, I'm right, my analysis is correct, my opinion is correct, and I'm not going to budge, and I don't care if this is like the most important information that's being brought to my attention. I'm digging my heels in, and I'm not going to consider it. To me, that is a big strike against their credibility. Whereas an expert that goes, "Wow, I didn't know that, I didn't hear that," the defendant didn't present any of those things that you're now showing me that are on jail calls or what have you. Yes, that will play. In other words, someone who's to admit that they're human and that maybe they didn't know about something, and that yes, sure, maybe that would play a role in their analysis, as opposed to digging in their heels and saying, no, I'm not going to consider it. I am correct. Don't sort of challenge me. That to me is a strike against credibility, as opposed to what the expert thinks they're doing and digging their heels in and really just sticking with their original opinion, if that makes sense.
Judge Speiser?
Yes, I mean, there's obviously a distinction between sanity and competency. And as Judge Singhal pointed out, sanity issues are resolved in front of a jury. Competency issues are pretrial matters that really the judge is serving as a one-person jury and deciding whether or not the defendant is competent or incompetent. So normally, from my experience, the defense attorneys, primarily the public defender's office, has their list of psychologists they normally use to address sanity. And the state attorney's office, the prosecutor's office, obviously has their list of individuals who are psychologists that address the issue of sanity, of competency. Now, the court also has the opportunity to appoint its own doctors, and we obviously, at least in Broward County, when I sat in that division, we had our list of psychologists that we interviewed before we allowed them to be on our list, so that we can select them to do evaluations as well. But the bottom line is, I think from a psychologist's perspective, you lose some credibility if all the time you're called to testify either for the prosecutor's office or for the defense attorney's office, because we're looking for a neutral opinion and evaluation, not an evaluation that is basically becoming routine and redundant because the psychologist is always testifying either for the state or for the defense.
Thank you, Judge.
And Dr. Brannon, if I might add,
Chair.
I know here in Broward County, before I left the bench, there were statistics that were brought towards us as far as what their opinions are found and how often. And the judges know this. So we had a particular doctor, I'm not going to name names, where it was like 95% of the time or 90% of the time he finds the defendant to be incompetent. And I don't know if the doctors realize this, but we're given these types of statistics by the parties. And so, somebody who finds something 90% of the time is a lot harder to take seriously and to listen to and to become an effective witness, as opposed to somebody who's more neutral.
Yes, thank you, Judge Scherer. True, and that study that you were talking about actually listed some doctors. The outliers were some doctors found individuals, defendants, incompetent 10% of the time, and others found them incompetent 90% of the time.
Right.
So as experts, of course, we worry about the judiciary's view of us in our profession when they see that kind of wide range. I want to move on to the next question. We've got a lot, and I'm going to jump around a little bit, and so thank you so much so far. Now, I'm going to bring up an area that people on this list have done research on. People who are viewing us here today have a great interest in this next question. And there's been a lot of debate in our profession about this, and that has to do with the ultimate issue question. And how far do we go as experts before we overstep our boundaries into legal decision making? In some areas, like in federal court, there's a rule that says we can't give an ultimate issue opinion on sanity, whereas we can in state court. So what's your feelings about how much you need as a judge for an expert to give you on competency and sanity and Miranda waiver evaluations to make a determination? Is it especially important for you to hear the expert give an ultimate issue opinion, or just lay out all the data they have for you to make your determination? And I'm going to start with that one with Judge Scherer.
To me, it depends on the expert, and I'm not just blowing smoke here, but if Dr. Brannon's in front of me and I want to, and let's say it's a really close call, I want to know, Dr. Brannon, what do you think? What's your opinion on the ultimate issue? I want to know, especially if it's really close. If it's a close scenario and it's a doctor that I trust, absolutely, I think it's more beneficial to hear their opinion on the ultimate issue, especially with competence, when competency is concerned.
Judge Singhal, Judge Speiser, any thought on ultimate issue opinions by experts?
Judge Speiser, why don't you go?
Well, as I said before, with respect to the ultimate issue, I'm a little bit more flexible with respect to them giving their opinion on the ultimate issue, that I have to decide as to whether someone is competent or incompetent when it's just me making that decision. But on the other hand, when it's a sanity issue where there's a jury present, and I understand the reason why a lot of federal courts have rules that a psychologist cannot say, I believe this person is sane or insane. We have more flexibility with respect to competency issues. And another thing that weighs heavily with me is more with respect to the background and history of the psychologist himself or herself. Have they actually ever worked in a forensic hospital, or have they ever worked in a civil hospital? To what extent have they dealt with people that have been committed to facilities? To what extent have they been involved with respect to prescribing medication? These are questions that I like to get into in more depth and detail, so that I can have a better handle of knowing where the person who is testifying, the psychologist, where he or she is coming from.
Now, Judge Singhal, you have the unique perspective of going from the state judge to a federal judge. So in state court, experts could give you opinions on sanity, but in federal court, they couldn't. So what's your thoughts now that you've seen both sides of that issue?
Sure. I probably am an outlier on this. With regard to competency, I think absolutely the doctor should be able to say, whether in his or her opinion, the individual is competent or not competent. We know a few things. We know competency waxes and wanes. We know that the determination is going to have been made well after the incident in question. We know the doctor typically can't relate it back to the date of the incident. And we know we're typically going to get 3 opinions, and we're going to have to decide where we're going with that. And it's not a 2-to-1. I mean, we could go with the 1. So you never know. As far as sanity, I don't think the ultimate issue was the person sane or insane. I think the ultimate issue was the person not guilty by reason of insanity? So if the doctor's going to say, I think he was insane at the time of the crime, well, that's a fact that the jury then uses to determine whether the person is not guilty by reason of insanity. I'm not going to let the doctor say, I would find him not guilty by reason of insanity. But I would be fine hearing from the doctor, it's my professional opinion based on A through F, that this individual was insane at the time of the crime.
Thank you, Judge. I've tried to pick hot topics that we're all very much interested in. That is the basis of many of our professional discussions. Judge Speiser, you get to start with the next one. That has to do with report writing. Do you as a judge prefer more detailed, longer reports with extensive histories, or shorter reports that focus more just on the legal issues in dispute?
I prefer longer reports so long as they're not primarily filled up with bluster and focusing really at the issue at hand. Because longer reports enable the evaluator to express to what extent has this person complied with medication compliance? Is there any indication that the person has been ordered to take medication but has not complied with that? Has a person ever been in a forensic hospital, and to what extent did that benefit the individual? What is the relationship between the defendant and his family? Is the family there in a support stature, or is he there basically aloof from his family and on his own or her own? So a lot of people say, well, listen, the more information we have in there, to what extent is it going to be valuable? And that's really for I as a judge to make that decision, but more is better than less.
Okay, thank you. Judge Singhal, Judge Scherer, report writing, short, long, what's more helpful?
Judge Scherer, why don't you go?
I'm going to go back to that. I think it depends on the expert. If it's an expert that I know, that I trust, that I regularly rely upon, then I'm going to say I like it just the way I like my orders. Address all the key points, address them in a intelligent way that can be understood, and hit the nuts and bolts. However, if it's somebody that I don't know as well, and maybe is a new expert, or one that I haven't dealt with, or one that I generally don't take them at their word, then I agree with Judge Speiser. Ultimately, if a matter is going to go to a final hearing, like on competency, then I'm going to want more of the information as opposed to less.
Okay. Any comments, Judge Singhal?
Yeah, I agree with both Judge Scherer and Judge Speiser on that. I prefer a longer report, particularly if the issue that's coming before me is sentencing, because I think at sentencing you want as much information as you can get. But to Judge Scherer's original point, I think the extensive history should be based on collateral sources. If it's
Yes.
only taken from the defendant, you're now in a position where at the hearing, the doctor's likely to be surprised by, well, did you know this? Did you know that? And if the doctor can't kind of move along with, oh, that would have changed my opinion had I known that, then you get into a credibility issue. But in general, I like longer reports.
So I'd like to follow up just a little bit on that question. How are we doing as a group, judges, in terms of our report writing? Are we in general clear and concise, or do we sometimes make difficult issues more difficult by our use of jargon and psychological terminology that clouds the issue as opposed to making it more clear? And I want to start with Judge Singhal on that.
I think it depends a lot on the judge. I think I developed this because of Judge Speiser really got into all of the objective tests. I looked at copies of the tests. I learned what the tests were about. And so I tried to get in a position where I wasn't confused by the jargon, where I really understood it. And in that sense, Judge Speiser and I are different from Judge Scherer because Judge Speiser and I both sat in a mental health division where every defendant was coming in with arguing that they had a mental illness. So, you kind of wanted to get to know things as much as possible. But I think it's like with anything, even a legal brief. If there's something in there argued that I don't understand, then I've got to go and learn it. And that's what I try to do.
Got it. Judge Scherer, Judge Speiser, any comments on how we doing in terms of concise reports and helping the issue as opposed to bogging it down, our report writing?
Yeah, I mean, let's face it. Let's face reality. The number of motions are filed to have the court appoint psychologists to determine whether someone is competent have quadrupled in the last couple of decades. It's amazing, and basically it's a matter of CYA for the defense attorneys. Cover your posterior. Okay, so they want to have every effort made to make sure that they're representing a defendant to the fullest. So that's why the system has been inundated with so many cases where people allegedly have mental health issues. To me, the biggest difference maker with respect to treating somebody that has mental health issues is the psychotropic medication. Psychotropic medication is so important for someone who is bona fidely mentally ill. So what I'm very much interested in is finding out if, in fact, this person has a history of mental health issues, what has happened with respect to his or her compliance with taking prescribed or court-ordered psychotropic medication. Because if they take the medication, I think they are exhibiting that they have the ability to improve their stature and their status in the eyes of the court. Because everyone knows that medication is such an integral part of restoration of competency.
Thanks so much. Just share any comments on that?
I think as far as testimony goes and report writing goes, most doctors either have it or they don't. What I will say is it is important to be able to be articulate and explain the issues. I'm not saying you have to dumb them down, but you certainly don't have to muck up the waters as far as trying to sound smarter than you are. Just say it. Just tell us what you want to tell us. Tell us what's important. Tell us the facts. Tell us the basis of your opinion, and really make it, hammer the issues that are important. And I will say that if I have the choice between appointing an expert who I can totally click with when they're on the stand, I understand what they're saying, they get to their point, they don't hem and haw, they just get right to it, that person is going to get appointed 10 times more often than the person who gets up there and just blah, 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 and never gets to the final point and lets me know what's the basis of your opinion, why do you believe this, and what supports you.
Judge Scherer, I'm going to start with you on this next one. What I want to say to all the judges, this next point is something that's very important to us as psychologists because it is what makes us different from all mental health professionals, and that's the use of psychological testing and intellectual testing. We pride ourselves in objective tools that are empirically based, that give us scientific information about the areas that we're assessing. So what weight do you as judges give to experts who use objective tools, MMPIs, Wechsler scales for intelligence, and malingering scales as well, as opposed to just relying mostly on clinical judgment and other forms of evidence? I'm going to start with Judge Scherer.
I'm a big proponent. I don't know if proponent's the right word, but I want the tests. And if I have a doctor who says that, oh, they didn't need to use any of that they just used their judgment, to me, that's a person who is rather full of themselves, and I'm not going to be nearly as likely to believe that person than an expert who's got it backed up with the scientific evidence and the proof and the testing. So I am a much more scientific person than one that's going to just believe the expert that goes on their gut, that goes on their clinical judgment.
I agree
Judge
with
Speiser?
that. I agree with that wholeheartedly. That objective, legitimate, recognized testing is a better measure than a judge that's walking in and giving a psychologist just walking in and giving his or her subjective opinion. Because, as I say, opinions are everyone has an opinion, and but it's not necessarily capable of being backed up without any objective testing, as far as I'm concerned.
Mr. Singhal, anything at all about the use of testing?
I agree completely with my colleagues on that. I would also say, though, that there are some what I call objective methods that aren't formal testing. And as an example, I've had, as a criminal defense lawyer and then as a judge, cases where you were the doctor, for example, and to ferret out whether someone was malingering, you went to the jail and you sat in a position where the defendant couldn't see you, didn't know you were there. And of course, this defendant who had been banging his head against the bars, you noticed, would stop his head a quarter of an inch before the bars every time and then slowly touch the bar, which suggested that he knew exactly what he was doing. So that's not an objective test like MMPI or wax or any of those kind of things, but it's kind of adding an objective part to a subjective test. And I think those are valuable also.
If I could just follow up on that one for 1
Judge
second.
Speiser.
The vast majority, unfortunately, of these defendants that have mental health issues, at the time they appear in front of us, they're in custody and they're in the jail. And the jail is a tremendous source of information that can help a judge make hopefully the right decision in terms of medication compliance within the jail, with respect to behaviors that are observed not only by the mental health and medical staff, but by the jailers themselves, who have actually interact with these people on a daily basis while they're in custody. And as Judge Singhal has indicated, malingering is a key big issue. And anything that I can get my hands on that would suggest that one of these individuals who is purportedly incompetent basically has indicia of malingering, that's very, very important and critical to me in making my decision.
Thank you, Judge. Judge Speiser, back to you. This is about testifying in court. I'm trying to get in all of our topic areas here, so I'm jumping around a little bit. I apologize for that. But I want to ask you all, because this is, again, an area of discussion and webinars that we've done over the years in our profession, kind of taking you all behind the curtain. And that has to do with, what kind of expert testifying in court has the most impact on judges and juries. So my question, Judge Speiser, starting with you, is do you view experts differently if they just exclusively do forensic evaluations? That's all they do. Or is an expert's testimony more valuable and useful if you also, and more credible, if you know they also do research or clinical work, or they've worked at a hospital, or those other kinds of things other than just exclusively focusing on forensic work?
I think you hit the nail right on the head. The more diverse the background of the evaluator, I think the more objective will be the results that they come to court to testify to. If all someone is doing is making their living just solely doing forensic evaluations, I have a little concern about that, unless they have a very diverse background, which they can point to that it has exposed them to many different scenarios other than just coming into court and evaluating and testifying about individuals that are the subject of competency or sanity issues. So yes, I mean the more expansive one's background is and the more diverse one's background is, I think just enables that and empowers that expert with a more objective and all-encompassing opinion.
Thank you so much, Judge Singhal or Judge Scherer.
I think one important thing to note is that the expert needs to understand their role. And if they are testifying in the role as a forensic psychologist, then their duty is to the court and to report factually to the court. And what I find is, while I think a diverse background is very important, but let's say at the time that they're testifying, the expert is doing 90% of their work clinical and only 10% forensic. To me, that often raises a big red flag, because it can become clear through their testimony that their loyalties or they don't understand the difference between testifying for the court as a fact, if they're reporting factually to the court, and having their testifying on behalf of their client. They can't there's no line. And I find those types of experts to be much less credible than ones that clearly understand the difference between when you're testifying as a forensics expert versus in your capacity as a clinician.
Thanks so much, Judge Singhal.
So again, I agree with my colleagues on this, but I can see it both ways. And for that reason, if resources are available, I think the best presentation, and kind of looking at it from either side in a criminal case, would be to kind of have a team. So as an example, one of the best presentations I ever had, Dr. Brannon, you were a witness as a forensic psychologist, and Dr. Daniel Bolber, who's a well-known psychiatrist here in Broward County, Yale medical doctor, testified as well. And so we had just the whole line of forensics to clinical covered with two different doctors. So if it's available, you don't necessarily want to look for someone who can cover everything, but you could have two people that cover their own portions, and it works very well, especially in sentencing and mitigation.
So judges, this next question, everyone would have come here today just to hear this question alone. So we're really anxious to hear your responses to this one. And Judge Singhal, I'm going to start with you on this, but there's a very important question to us. So when testifying in court, what are the things that work? What are the qualities that are the most effective in terms of experts who testify in front of you all that you give the most weight to? And what are the things that we do that are distracting and annoying and that you wish we wouldn't do those kinds of things? So tell us what's helpful and what's not so helpful in terms of our court testimony in front of you. Judge Singhal?
Sure. I personally think that, like with anything, as you testify more, you get more comfortable with it and you get better at it. Not that it's something that you practice so that you are trying to deceive anybody, but the first time you testify, and look, I've testified in hearings as well, but it's pretty off-putting. And you might speak too fast, or you might not directly answer the question. You might turn and look at the judge as opposed to looking at the person who's asking you the question. But some of the negatives that I've actually seen is you have the witness next to you, and in between, while the question's being answered, they're looking at their cell phone. I don't have that anymore in federal court because they can't have their cell phone with them. But to me, I know they're not listening to the question. They're not playing games. They're actually looking for a study that dealt with the last question, but they're missing the current question. And so I do think you really have to focus on the question and be responsive to the question. And also don't answer more than what was asked. That's a very difficult point for witnesses to understand, even lawyers if they're testifying, because all that does is open you up for cross-examination. And really what you want to do is focus on what was asked.
Thanks so much. Judge Scherer, Judge Speiser?
Well, I think it's very important, and this is actually the substance of one of your questions here under testifying in court, is what is my opinion with respect to a witness, a psychologist, in terms of should they be looking at the court when they're answering the questions, or should they be looking at the defendant and the lawyer that is hired to represent him or her. So I think eye contact speaks volumes about the sincerity and the intensity of the posture of the psychologist who's testifying. They should be looking at the judge. It's very, very important. Another thing that's very important is in terms of making sure they present a full panorama of the life of the individual who's who they're testifying about. In other words, what is his or her history with respect to medication compliance? I've stressed that it's very, very important. What type of treatment has he been exposed to he or she been exposed to in the past? Have they been residents of facilities and programs, and how have they done there? Do they have do they have a support network in the community that they can look to? Do they have any counselors that have been they've been exposed to that can speak either positively or negatively on their behalf? The more that the psychologist travels in terms of garnering this information and presenting it to the court, I think really enhances the legitimacy of what the psychologist has to testify, and to me, it empowers a lot more credibility in his or her testimony.
Got it. Judge Scherer, any comment on what works and what doesn't work with expert witness testimony?
I think this is something that can probably be true for new lawyers, just like new witnesses. A lot of times people think that if they come across as you know, I'm smarter than you think, and I have these credentials and so on and so forth, that the person comes across as arrogant as opposed to relatable. I think that the most important part of testifying is to be relatable to the judge and to whoever's in the room. So you can explain yourself, explain your credentials, again, without coming off arrogant, and with answering the question that's before you, as opposed to going into this long narrative where you just sort of try to outsmart whoever else is in the room. That does not come across as confident. That comes across as arrogant. And those types of witnesses, in my mind, I shut it off, and I don't believe anything that they say.
Thanks so much. Dr. Perillo, I know you're listening, so I see a lot of questionings building up. So I'm going to ask
one thing, though. Judge Speiser, could I add one thing?
Yes, of course. I'm sorry, Judge Singhal.
No, I hate to do this, but I think, kind of thinking about Judge Speiser's point about eye contact with the judge, I definitely understand that. I think that is probably how people are taught to testify, to look at the decision maker. I've actually not been a proponent of that, only because in many of the hearings I get, not just mental health hearings, but suppression motions, I don't want the police officer looking at me. And so I would rather them just look at the person asking the question. But I don't think that you should take what I said about the eye contact to the bank, because I think Judge Speiser's position on that would probably be much more authoritative.
Dr. Perillo, I'm going to ask two more questions and then get it to the audience because there's so many questions. So I'm going to ask two more brief questions and move on to the audience, if that's okay, because I see a lot of questions in there.
That is okay, although I will add that you and the judges here have had an incredible timing of answering a lot of the questions that people have answered here so far. So
okay, good.
I might redirect to additional questions to you, because many of these appears you have answered like 5-10 minutes later.
Or well, maybe in the last two, we'll cover some of that as well, because they're two more important. So thank you, Dr. Perillo. I want to ask you all about conversation, and Judge Scherer, I'm going to start with you on this, about bias. We're very concerned in our profession about potential bias, but it's not just us. I mean, people who are experts in fingerprinting and people who are experts in ballistics. We have research that says who hires you and who hires you on a regular basis can influence you as an expert in terms of your opinion. So how well do you think we all do in that issue of bias? And do you worry about that? And some of you have alluded to it earlier already, about which side hires somebody, how many times they're hired by one party or the other, as opposed to court-appointed experts. And Judge Scherer, that's your question.
Sure. I was just sort of thinking about it for a second. To me, let's say you have 10 experts. There's going to be one side of the spectrum that you know are more biased towards finding somebody competent. There's going to be one side of the spectrum that's going to be finding competent and incompetent. And then you have the ones in the middle. And I rarely appoint the ones that are on the very outskirts of that sort of 1 through 10 scale. I think that if you do your best to be thorough, give the tests, the required tests, objectives, give as much information as possible. I think that that's the best way to come across to courts as credible. And I think that eventually, I mean, when I was a prosecutor, we had what we called our naughty and our nice list. And the naughty list was experts that we would always object to, because we know they always find, one way or the other. And then we have the nice list, meaning ones that we thought could be objective. And I kept that list when I was a judge, and then added to it, because there were some experts that no way, I'm not appointing them, because it's a waste of the court's time and money. And then there's some that are always very, very ethical, very, I'm sorry, I'm trying to think of the word. They get to all, they cover all the bases. They interview the jail staff. They interview different sources, and they give the different objective tests and things like that. And I know that I can rely on those people.
Judge Singhal, Judge Speiser, this issue of bias, we're very interested in this area and talk about it a lot in our webinars.
Well, I do something probably most judges don't, and that is I want to know more about the psychologist himself or herself. Has a psychologist ever been a victim of a crime themselves? Has a psychologist had anybody in their family or anybody that's very close that has endured mental health issue and gone through mental health treatment? I think that's very important because, I mean, we're taking somebody who's coming. I don't ask that to the same psychologist who testifies routinely in front of me, but when I have a psychologist testifying that I've never seen before or heard of before, I want to know where he or she is coming from. I mean, that may very well affect their objectivity, and it may very well suggest that perhaps there is some bias in the perspective of what they're testifying about.
Judge Singhal?
So everyone's biased. I mean, it's just a fact of life. And so this is going to affect people, whether it's criminal or civil, whether it's psychiatric or psychological experts, or an expert on damages in a big civil case. And, you do want to have all that information. Sometimes, though, and again, from a criminal defense perspective, the pool of experts that you can choose from is pretty small. So, I used to do death penalty defense, and there was a great local expert here. He just passed away, Dr. Jethro Toomer, but he would take cases no one else would take. And sometimes you just need to hire that expert. I think from a defense perspective or a psychologist perspective, that's the kind of expert you would have go in and do their evaluation, but not actually testify, but sit in court and feed you questions. So you knew how to attack the other expert. So there's different uses for experts as well. But as far as bias goes, I mean, I don't think there's anything someone can do to walk in and say, I'm not biased. I think that's a bad answer. But it's just something we all have to live with.
So this next and last question starts with Judge Speiser, and again, something that we're very, very interested in. I want to ask you all about Daubert hearings, but not just Daubert hearings that you may or not have been involved in, but just the idea of admissibility of expert witness testimony. I've seen all of you make rulings, and Judge Scherer, most recently, I saw you make rulings in terms of admissibility of experts and expert testimony in the Parkland case. Starting with Judge Speiser, can you talk to me about any Daubert hearings, things that experts can do to avoid Daubert challenges, and what kind of issues you've possibly seen come up that address the area of admissibility of expert witness testimony?
Okay, I have not sat in the criminal division for approximately 15 years. Okay, but and Daubert really came into reality. The Daubert decision came into reality within the last 5 years, 5 to 6 years. So when I was sitting in criminal, that was not really a major consideration. But after seeing this question that you sent to us, the list of questions, I didn't feel like I was in a position to really comment on that because that was not an issue that came in front of me. So I did some research, and there's a great article I would highly recommend in the Journal of American Academy of Psychiatry and the Law. It's called Daubert Considerations in Forensic Evaluations by Telepsychiatry. And it appeared in the September 2022 edition of that publication, Journal of American Academy of Psychiatry and the Law Online. So that really is an escape for me not to answer that question because I didn't really have that issue come up while I was sitting as a mental health court judge. But again, we're talking here about people's psychiatric issues and personality. I don't know how well Daubert would fit into that as a basis for of being a major factor. I mean, we're talking about individual behavior, individual shortcomings, individual compliance with medication therapy. I just don't see how Daubert comes into play as strongly as in more civil, in more routine civil cases.
Mhm. Judge Scherer, Judge Singhal?
Judge Singhal is the expert on this. He teaches it at judge school. So Judge Singhal.
So I want to clarify one thing as far as what Judge Speiser said when he said Daubert's only come in the last 5 or 6 years, since a lot of people on this Zoom are from New Mexico and out of Florida. So Florida used to be a FRI state, which was a different standard for admitting this kind of testimony, and then went to Daubert not all that long ago. And I think that's what Judge Speiser is referring to, because interestingly enough, Daubert came out in 93. But My Cousin Vinny came out in 92, which is the best Daubert movie that there is, because it's perfect for that. All of that having been said, though, I think that the testimony that the doctors on this Zoom would give shouldn't be an issue that Daubert would affect. But in terms of some psychological testimony that I have had where Daubert's come into play, it would be in the area of false identification, eyewitness identification, interrogatories or interrogation techniques, and things like that. And it's difficult because under Daubert, you have to look at things like reliability and error rates and things like that. And it's difficult to give testimony about false identification and really deal with error rates. But that's another area, Dr. Brannon, that you've been able to get past Daubert on that. So you just have to be skilled at knowing what the elements are under Daubert and be able to answer those questions so that the judge is convinced that you offer something that could assist the trier of fact.
Thanks so much. And Judge Scherer, I know it wasn't Daubert issues, but I know you had a lot of admissibility issues in terms of experts, 35 experts in the Parkland case. So can you talk a little bit about the decision-making in regards to what was admissible and what wasn't?
I mean, the science needs to support whatever the expert is testifying to. And in the Parkland case, as part of the defense strategy was to hire all these different experts in all these different fields, and the science just, I can say for the most part, just did not support what their experts were going to testify to. In fact, most of their expert witnesses out of 35 or so, or Dr. Brannon, I don't know if you just said the amount, but they hired numerous experts, and most of them I didn't even have to make a ruling on. They withdrew them at the very last minute because they knew that the science wasn't going to hold up. So, you can find anyone to say anything if you look hard enough. Don't be one of those people. That's my advice.
Mm-hmm. So Dr. Perillo, I'm going to turn it over to you at this point. I want to thank all three of you judges. We're going to take questions from the audience, but thank you so much. It was an honor to do this, and I appreciate your time.
Yes,
Thank you for having all of us.
This has truly been invaluable. Thank you so much first for the time dedicated here, Dr. Brannon, for organizing all of this. I am also impressed with your speed round sheer efficiency of addressing all these questions and answering them, getting as much into this panel as we possibly could. As I mentioned, you've also been able to really predict what a lot of people are asking. I'll try to supplement with some of those here. Shortly, the QR code for those that need for the APA continuing education will be posted, and the link will be posted in the chat box as well. You have all talked about recommendations for people that are early in getting into testimony. One context here is I've trained forensic fellows who are early in their career, who have the training but have not testified yet. And so one question here is, what recommendations do you have for early career professionals who are less familiar with providing expert testimony? What are some things that early career professionals can do to establish credibility in the absence of that track record of having extensive testimony experience in the past?
So if I could go first on this, my suggestion would be, if possible, to watch well-respected doctors testify. I think the same advice would be true for young lawyers. I always would tell my law students or young lawyers, go watch some of the legends to try a case. And it's just amazing what you can learn in terms of the court presence and the way things are answered, and the fact that if someone tries to get under your skin, you just don't let them, things like that. I think watching other people really goes a long way.
I also think when I worked for the state attorney's office, we had 2 or 3 prosecutors that were assigned that were really good at mental health cases. And so as a young lawyer, I would go and sit down with one of these more experienced lawyers and say, okay, here's the doctor's report. Can you help me go over what is important in this report and what I should ask? And I would think that for new doctors, the same types of things would be important. In other words, find somebody who's an expert in your field, like Dr. Brannon, who's testified a gazillion times. Maybe you can call them up and say, okay, here's what I'm testifying about. What do you think is important? What do you think I should mention? And also, if you can sit down with the prosecutor or the defense and you can ask them to sort of go over what they're going to ask and what you think is important, what they think is important, I think preparation and the details all make the difference.
From my perspective, I mean, everyone can basically do the basics, okay? In this particular field, in any other field, you can dot your I's and cross your T's and probably get to first base and maybe even a second base. But to really score a home run and you're relatively young and doing this for the first time, it's going the extra yard in terms of delving into, as far as possible, the mental health history, compliance, lack of compliance of this individual with respect to meeting with their counselors, taking psychotropic medication. These are all factors that I think are very important. And the other thing is I place a big emphasis on eye contact. Now, sometimes people have a hard time looking at me, but putting that aside, I think that if you're confident in what you're saying, you have no problem with eyeballing the judge or to whoever else you're trying to convince that what you're saying is true, accurate, and honest.
This might tie into that eye contact logistic consideration here, particularly over the last 5 years. Of course, there has been an influx of remote testimony and remote court settings. And some people asked a question of, do you find any additional considerations or differences for people that are providing testimony remotely on Zoom? Is there anything that we as experts should be considering in how we present testimony remotely? Any things that you have found particularly effective or ineffective?
Well, you seem to be eyeballing me as you ask that question, so let me see if I can answer it, eyeballing you back. To me, I think an expert, if he or she wants to be more effective, should reject the option and opportunity to testify remotely, but rather should be there in court. I think it just has such a greater effect, a more positive effect if you can testify in court as opposed to testifying remotely. Another thing that's very important is when you're testifying remotely, and a lot of times when I say remotely, you either it could be a videotaping of your testimony and then played back to the jury, or you can be at an offsite location and testifying under those circumstances. But if it's a former where your testimony is being presented after it's being videotaped and perpetuated for the hearing or for the trial, the jury can't ask you any questions. In Florida now, and I don't know how many other states allow this, the jury can ask witnesses questions after the witness has been completely questioned by both the plaintiff and the defendant, and also by the prosecutor and defense attorney. The jury can be asked, do you have any questions you want to ask this witness? So if you're testifying and your testimony is preserved because of unavailability to be at the trial, there's no questions that they have an opportunity to direct to you. So that's very, very important. If you can testify live as opposed to remotely.
100%, I agree.
Me too. Yeah, I think live testimony, it's all, I mean, look, remote testimony now, it's a way of the world and a way of our practice, but if you can be there in person, it really benefits your side.
We are at the top of the hour. I do want to be mindful of our judges' times who's taken their time to present here. As you can see in the chat box, click the link for the survey for APA continuing education credits if you are interested in that. Judge Speiser, Judge Singhal, Judge Scherer, and Dr. Brannon, thank you so much for your time here. I think, we so oftentimes talk about advice and expert testimony within our own silo as psychologists based on our own individual experiences or as we perceive them. And getting direct perspectives and hands-on experience from judges themselves, I think, has been an eye-opening perspective for a lot of people here. So thank you so much for your direct, candid, honest feedback based on your experiences on the bench. It is much appreciated.
I just want
Thank
to
you.
say one shout for Dr. Brannon. He did a phenomenal job, not
Made it
only garnering us, but also his time he spent in preparing these questions and points he wanted to get across. And he is a phenomenal forensic psychologist.
Thank you, Judge.
Totally agree. Totally agree. Thank you for
Thank you
having
all.
us.
Thank you so
Bye-bye.
much,
Thank
Mike,
you
and
all.
thank you so much, judges. And that does wrap up this week's Law and Mental Health
Well.
series. Next week, we have Dr. Stephen Gold, who will be discussing psychological experiences of those involved in capital executions. We hope to see you then for another great discussion of issues in behavioral health and the law. Until next time, have a great rest of your week.
Thank you.
Thank you.